beloved brothers and sisters, good evening to all. We are here to heading into the second lecture, Orientation Committee, in the subject of Penal Code and Overview. I request Committee Chairman Mr. ALAGUMANI sir to give welcome address.
இந்த இனிய மாலை பொழுதிலே MBHAவின் ஓரியன்டேஷன் ப்ரோக்ராமிற்கு வந்திருக்கும் அனைத்து வழக்கறிஞர் நண்பர்களுக்கும் இந்த நிகழ்ச்சியை இடைவிடாது ஒவ்வொரு வாரம் புதன்கிழமையும் கட்டாயம் நடத்த வேண்டும் என்று கட்டளையிட்டிருக்கும் எங்கள் சங்கத்தின் தலைவர் திரு பி ஆண்டிராஜ் அவர்கள், செயலாளர் திரு அன்பரசு அவர்கள், துணைத் தலைவர், இணைச் செயலாளர் மற்றும் பொருளாளர் அனைவருக்கும் வரவேற்றுக் கொள்கிறோம். மேலும் நமது மதுரை உயர்நீதிமன்றத்திலே நீதியரசராக பொறுப்பேற்று முதலிலே நமது சங்கத்திற்கு வருகை தந்திருக்கிறார். அவரை எங்கள் சங்கத்தின் வழக்கறிஞரின் சார்பாக அன்போடு வருக வருக என்று இருகரம் கூப்பி வரவேற்பதில் பெரும் மகிழ்ச்சி அடைகிறோம். நமது நீதியரசரை நமது சங்க உறுப்பினர்கள் சந்தித்து இந்த ஓரியன்டேஷன் நிகழ்ச்சிக்கு வர வேண்டும் என்றபொழுது உடனடியாக அதற்கு ஒப்புக்கொண்டு எந்த தேதியில் வேண்டுமானாலும் நமது உறுப்பினர்களுக்கு பயிற்சி அளிக்க தயாராக இருக்கிறேன் என்று உடனடியாக ஒப்புதல் கொடுத்தார். அதற்கு நன்றியினை தெரிவித்துக் கொள்கிறோம். உங்களுடைய நீதியரசரின் ஆதரவு இந்த வழக்கறிஞர் சங்கத்துக்கு நிரந்தரமாக தேவை என்பதனை இந்த கணத்திலே தெரிவித்துக் கொள்கிறோம். நமது நீதியரசர் அவர்கள் நமது வழக்கறிஞர் சமுதாயத்திலே ஒரு மூத்த வழக்கறிஞராக 1990ஆம் ஆண்டு முதல் பல்வேறு முக்கியத்துவம் வாய்ந்த வழக்குகளில் அவர் திறம்பட வாதிட்டது மட்டுமல்லாமல் பல மூத்த வழக்கறிஞர்களுடன் இணைந்து பணியாற்றியுள்ளார். மூத்த வழக்கறிஞர்கள் திரு ஹபீபுல்லா பாஷா அவர்கள், திரு இலியாஸ் அலி அவர்கள், திரு என் நடராஜன் அவர்கள், நமது அட்வொகேட் ஜெனரல் திரு சண்முக சுந்தரம் அவர்களுடன் இணைந்து தனது நீண்ட நெடிய வழக்கறிஞர் பயணத்திலே பல மைல்கல்லான பல தீர்ப்புகளை திறம்பட வழங்கி தற்பொழுது நீதியரசராக சிறப்பாக செயல்பட்டு கொண்டிருக்கும் நமது நீதியரசரை வருக வருக என வரவேற்கிறோம். இந்த நிகழ்ச்சி நமது MBHAவின் சார்பாக தொடர்ச்சியாக ஒவ்வொரு புதன்கிழமையும் நடைபெறும். அடுத்த வாரம் நமது மூத்த வழக்கறிஞர் திரு அஜ்மல் கான் சார் அவர்கள் நம்முடைய பயிற்சியாளராக கலந்து கொள்ள சம்மதம் தெரிவித்திருக்கிறார். ஜனவரி மாதம் முதல் புதன்கிழமை மாண்புமிகு நீதியரசர் ஜெகஜீஷ் சந்திரா அவர்கள் நம்மிடையே உரையாற்ற ஒப்புதல் அளித்துள்ளார்கள். அவர்களுக்கு நன்றியினை தெரிவித்துக் கொள்கிறோம். நன்றி, வணக்கம்.
Thank you, sir. Now I request our bar president, Mr. ANDIRAJ sir, to give presidency address. Say a few words about our lordship.
Dear members of the bar and my senior colleagues and my junior lawyers and young lawyers and my friends and sisters, on behalf of the bar, on behalf of everyone, I am extremely happy to receive your Honorable Justice Sunder Mohan. A brief note about our lordship. Our lordship was born on 2/11/1969 to Mr. S. Sundar, senior advocate, and Subalakshmi in Kunnur. Our lordship has been completed his law degree in 1991. Enrolled as an advocate on 9/10/91. I think it's right. I am also enrolled along with Justice. It is a double proud for me to welcome our Honorable Justice. And then initially he was attached with Senior Counsel Mr. N. Nadarajan. Needless to say that he is one of the legend of our criminal bar. It's a proud to say that he is our bar. His lordship was attached with Nadarajan and assisted in so many cases. I think 2 cases I remembered. One Rajiv Gandhi assassination case and another one is Bombay bomb blast case. Thereafter our lordship was attached with Abhibullah Basa, senior advocate and advocate general of Tamil Nadu, then associated with Ilyas Ali, and later lordship was joined in the office of senior advocate, now advocate general Shanmuga Sundaram sir office, where he gained lot of experience in criminal law. Not only that, he is a resource person for Tamil Nadu Judicial Academy and Tamil Nadu Police Academy, taking lot of lectures for civil judges and senior judges and district judges, I think, even in the year 2016, 17, 18. and he also conducted trainings program for Director of Prosecution. Having a sound knowledge in criminal law, and our Lordship is elevated as a judge of Hon'Ble High Court Chennai on 6/6/22. Thereafter, it is needless to say that he is friendly and very affectionate towards our bar, and hopefully our members are requested to gain lot of knowledge from our Lordship. I don't want to take much time because like you, I am also very eager to hear the speech of our Lordship, Mr. Sunder Mohan. Thank you once again.
Thank you, sir. I request Honorable Justice to take us into the session of Penal Code and Overview. We are happy to lend our ears to you.
Good evening, all of you. Two things before I begin the formal session. Two things I like to share with you. One is, this place is simply too good. This Madurai, not only the place as such, this High Court, I am thoroughly enjoying it. Though it is a short period since I came here, I am thoroughly enjoying it. The calmness, the way the court is functioning, I am very happy that I am here. Secondly, this might please you. I find the bar members to be very good. The bar members are well prepared. They are doing extremely well. So I am very happy that this. The first time I came here was in 2003. Immediately after the court was formed, we were engaged in a few matters. We came here for a few years. After that, they stopped engaging us. I was wondering why they stopped. Then I realized the lawyers here are doing much better. So it's amazing that from the day that I saw, that is in 2003, now there is a sea change. The bar members are doing extremely well. So keep it up. I should thank the organizers for calling me. It was a good opportunity for me to meet you all. This hall is named after a legend, NTV sir, and I feel that when I am talking about penal code in this hall, that he is watching and my senior is watching. They were both colleagues. And were with the another legend called Mohan Kumar Mangalam. I don't know how many of you have heard of him. He was a minister in Indira Gandhi's cabinet, and he was a legend himself, and he produced a number of legends, including NTV sir, my senior Mr. N. Rajan, etc. So the first thing that my senior taught me when I entered his chambers was not law. He said how to conduct yourself in court. When Mr. Mohan Kumar Mangalam wanted to become a lawyer, he was then in Communist Party, he wanted to become a lawyer. He asked his father for advice. His father was Dr. Subbarayan. He was in the Nehru cabinet. So they were all in Congress Party at that time. So he asked his father for his advice, and he said, meet my friend Mahajan. Mahajan was then the Chief Justice of India. So what should I do? He came late into the profession. He was almost into his late 30s when he came into the profession. So he met Chief Justice Mahajan. Mahajan said, what is the advice, sir? What would you advise? I want to enter this profession. He says, there are 3 basic rules that you should follow in court. It was law, everybody can study. It is all available on book. Now it is even easier. Said, first study the judge. Study the judge well. You must read his mind. To be a good advocate, you can write articles by reading law, but in order to be a good advocate, study the judge. Then the second thing he said was, study the facts thoroughly. Then, if time permits, study the law. So that was the advice given in the 50s, and it still holds good. Ultimately, now as a judge I can tell you, all of us have some notions. You will have to try and exploit that notion. That is the art of a good advocacy. Then facts, you must be thorough. You shall not mislead the judge on facts. You must be very careful on that. Law, the judge will take care. Judge will take care, the other side will take care. So the importance given to law was came as last in the order of precedence. So with that note, let us get into this formal discussion. So let us make it more interactive, right, so that you also participate in what we are going to discuss. All of us know that penal code is there for about 150 years, 60 years now, 1860. We all know that. You all know when was the first draft made? First draft. Any guesses? The first draft was made by Lord Macaulay in 1837. Thereafter it was waited for so many. They had again a lot of hiccups, bureaucratic hiccups. Then ultimately it was tabled in 1860. Between 1837 and 1860 there were a number of amendments, number of changes, not amendments, or unless it's an act it's not amendment, number of changes to the penal code. And Sir James Barnes Peacock, ultimately he finalized the penal code. So between 1837 and 1860 itself there were a number of changes to penal code. The original structure was created by Lord Macaulay. The definition of murder that we see today was not there in the penal code. And we find in property offences, which are the two major ingredients in property offences that one has to establish. What are the major ingredients in property offences? Any guesses? Either it has to be property offences, what are the ingredients that you have to establish? Dishonestly or fraudulently. In property offences you will either find dishonestly or fraudulently. In theft alone you will not find fraudulently, because theft is I'll tell you reason for that also. In the 1837 draft there was no dishonestly. Fraudulently, the definition given for dishonestly was the definition for fraudulently in 1837. I am telling you all this thing is, it has gone through some changes in between that period also, and after that it has stood the test of time. Seri. For act, enactment, anything that you want to master or you want to understand, you must first understand why. எதுக்காக இந்த code was enacted. So what was before that? யோசிக்கிறோம். This came in 1860. What was before that? Before that there were certain acts in various states. Over state penal law was administered differently, except for serious felonies. Felony na serious crimes. Serious crimes like rape, murder, dacoity, theft. இதெல்லாம் universal. It was never considered to be a innocent act. அதாவது ரொம்ப காலமாவே murder, rape and all that. Now அதிலுமே how do you define murder? They could have simply said, if A causes the death of B, that is murder. சொல்லிருக்கலாம்ல, சொல்லல. This is the complicated definition. Many people even struggle to understand the difference between culpable homicide and murder even today. Reason is that was a check given. இப்போ ultimately என்ன நடக்குது? A caused B, A caused the death of B சொன்னா போதாதா மர்டருக்கு? அதானே நம்ம கொலைனா என்ன? இன்னொருத்தன் உயிரை ஒருத்தன் எடுக்கிறான். So they could have simply said A causes death of B, it is murder. சொல்லிருக்கலாம்ல. That is the pain they took to check. ஏன்னா நீங்கள் அந்த மாதிரி ஒரு வைட் டெஃபினிஷன் கொடுத்துருந்தீங்கன்னா what would have happened? 304A கேசஸ்க்கும் லைஃப். Culpable homicide not amounting to murder, you can give death to life. The resultant act also was by itself not the entire thing in a criminal case. So they gave importance to the mental state. So how do you classify certain acts as offences? That was their first concern. ஏன்னா உலகம் பூரா ஒவ்வொரு நாட்டிலையும் ஒரு மாதிரி அஃபென்ஸ் இருக்குது. ஒரு நாட்டில் ஒரு அஃபென்ஸ் இருக்குது, இன்னொரு நாட்டில் அது அஃபென்ஸ் இல்லை. ஒரு ஏரியாவில் சில அஃபென்ஸ் இருக்குது, இன்னொரு ஏரியாவில் அது இல்லை. சரி, இப்போ யூனிவர்சலாக எப்படி இதை பண்ணுறது? ஹவு டு வி மேக் தட் வாஸ் த சேலஞ்ச் பிஃபோர் தெம். Then they went and borrowed it from certain Napoleon code. They brought it from code of Louisiana. Adella number, it may not be relevant for the purpose of understanding. Let us only to understand the history vechupom that. Ultimately they followed a pattern. In a pattern na, the pattern, this is my understanding, they did not make all immoral acts as crimes. எல்லா immoral actum crime ஆக்கல. So the penal code framers themselves have given an example. இந்த எக்ஸாம்பிள் என்னன்னா, மெக்காலே இந்த ஹிஸ்ட்ரி சொன்னல 1837 கோட் மெக்காலே சொன்னார். அதில் ஒவ்வொரு சாப்டரும் பண்ணதுக்கப்புறம் they appended a note next to every chapter. அதில் one of the chapters offense against marriage இருக்கு இல்லையா, அந்த சாப்டரில் they appended a note. I think it is either G or H, but this note has been extracted in one of the Supreme Court judgments. I'll give you the citation. இப்போ நீங்கள் ஜஸ்ட் கேட்டுக்கோங்க. I'll give you the citation. I'll give it to your bar president. Subramaniam Swamy was state in 1990. அதில் what the framers think பண்ணுறது உங்களுக்கு அதில் ரிஃப்ளெக்ட் ஆகும். ஒரு ரிச் மேன் இஸ் காட் bags of rice in his house. A poor man is starving to death. வெளியில் வீட்டு வாசலில் is starving to death. The rich man does not feed him, he dies. He knows that he is starving to death. He's got bags of rice, he can give him. கொடுத்தா he will survive, but he doesn't give. This is one situation. The second situation is the poor man since he is starving, வீட்டுக்குள்ளே போய் திருடி சாப்பிட்றார், ஆர் அந்த ரைஸை திருடிடுறார். which one is more immoral? எது இதோட ரெண்டுத்தில் எது ரொம்ப தப்பு நம்ம மனசளவில்? கரெக்ட். ஃபர்ஸ்ட் ஒன் இஸ் நாட் அன் அஃபென்ஸ். ஸோ இந்த ஐடியாவை ஃபர்ஸ்ட் வி மஸ்ட் கெட் இன் டு அவர் சிஸ்டம். we shall not try to make and fix all immoral acts into offenses. முதல்ல what is the offense that is defined, what is it that they wanted to define, what is it that they wanted to create as an offense, அதை understand பண்ணணும். They themselves have said we are incapable of making எல்லா immoral actum into an offense. We cannot make that. அப்படி பண்ணால் what is immoral in one society may not be immoral in another society. So there will not be any scientific pattern. So they wanted to create a scientific pattern. What is the scientific pattern? Anybody with guilty intention, that is what they call as mens rea, harms another person's body, mind, reputation or property. Guilty intention, if he attacks. So இப்போ now we fit in that first story நான் சொன்னேன் பாருங்க. You now fit in that story. Now the man who does not feed the other person, he does not harm the persons with guilty intention, with mind, property or reputation. His immoral act has led to his death, that's a different matter, but he has not harmed his mind, property, reputation or body. So this is the basis. Now where do you get this basis? You see the definition of injury in section 44. Injury na enna? Causing harm to section 44 la. That is the basis of the entire penal code. Causing harm to one's property, body, mind or reputation. Alright. அது மட்டுமா அப்படின்னா இல்லை. There are two other artificial institutions created for man's benefit. What are they? Institutions created by man. That is, one is state the other is institution of marriage. They wanted to protect these two institutions also. So person who harms those institutions is also liable. That is why you will see in bigamy the wife is not punishable. The husband, the third person is punishable because bigamy is punishable. In adultery, now of course they made it not an offence because gender neutral, they wanted on parity with gender. So anybody who attacks or causes harm to that institution of marriage shall be punishable. That was the idea. Again, offences against state, not offences against state mattum paakadinga. Corruption is you are corrupting the system by corrupting. Therefore that is an attack on the institution of state. Likewise, disobeying public servant, idhu attack on state. So in the classification level they did it. All right. Now நம்ம எல்லாம் காலேஜில் படிக்கிற first lesson என்ன? There are 4 stages in a crime. What are the 4 stages? இல்லை ப்ரிப்பரேஷன் முன்னாடி ஒரு ஸ்டேஜ் இருக்கே, mens rea. Let us use the language employed by the mens rea. அதுக்கப்புறம் ஆக்டர்ஸ் ரியஸ் நடுவில் 2 ஸ்டேஜ் இருக்குது. அதுக்கு நடுவில் preparation, then is the attempt, then the 4th stage is punishment. So penal code followed a pattern. In a pattern அப்படினா first 2 stages we will not make it punishable. Of course there are exceptions. The exceptions க்கு அப்புறம் வரும். நம்ம முதல்ல ரூலை நல்லா அண்டர்ஸ்டாண்ட் பண்ணிப்போம். First 2 stages let us not make it punishable. Attempt and the actus reus is punishable, but of course it has to have the ingredients of mens rea. All right. Now in the stage la புரிஞ்சிட்டீங்களா? So penal code la what are the mental states which are contemplated in penal code? அதாவது mens rea என்றது wide term. Mens rea can be in different forms. What are the mens rea or mental states that is contemplated in penal code? சொல்லுங்க. Very good. Voluntarily yaar sona? You said voluntary. What do you mean by voluntarily?
Knowledge of causing a harm. Doing it with intention.
Yes, correct. So sit down. You are coming close to it. So now let us have clarity in our thinking. What is the mental states? That is, what are the mental states contemplated in penal code? Offensesலாம் நம்ம வந்து இன்டென்ஷன் நாலேஜ்லாம் படிக்கிறோமா இல்லையா? படிக்கிறோமா? The first mental state is intention. That is the highest form of culpable mental state. Highest form is intention. Then the second highest is knowledge. Then we have something called reasons to believe. This is the third thing that we normally don't have in all offenses. 4 is சொல்லுங்க. Anybody? Three not 4A intention knowledgeலாம் இருக்கா? அதாவது ரிசல்டன்ட் ஆக்டுக்கு இன்டென்ஷன் நாலேஜ் இருக்கா? இல்லை. தி மென்டல் ஸ்டேட் தட் இஸ் ப்ரொவைடட் இஸ் ரேஷ்னஸ் ஆர் நெக்லிஜென்ஸ். தேர் ஆர் ஃபியூ அதர் mental states will not complicate it. இதெல்லாம் நம்ம காமனாக யூஸ் பண்ணுறது மட்டும் we will go, but I will come to exceptions a little later. Now ஜென்ரலாக நம்ம யூஸ் பண்ணுறது மட்டும் நம்ம பார்த்தோம். So where do you get these are the mental states அப்படின்னா you see section 39. One of you have penal code. யாரா ஒருத்தர் படிச்சிங்கன்னா இன்னும் it will be take this penal code. யாரா படிங்க, so that for the benefit of others also. Yes, yes.
A person is said to cause an effect voluntarily when it causes it by means and by he intended to cause it.
Intended நிறுத்துங்க. intention வாலண்டரிலி தான் உங்களுக்கு செக்ஷன் 39ல வருது. செக்ஷன் 39 வாலண்டரிலினா நம்ம many of us think it is own volition. English voluntarily is different from penal code voluntarily. முதல்ல let us get that into our system. Penal code voluntarily has got a different connotation. You must understand that. Now that is defined in section 39. Padinga.
Or by means which at the time of employing those means he
New knowledge. This is the second type of mental state. Alright.
or had reason to believe to be likely to cause it.
Alright. So, மூணு mental states. What is the difference between these three mental states? Now think. Now don't wait for me to answer. நீங்கள் யோசிங்க இப்போ மூணு மென்டல் ஸ்டேட் இருக்கு. இன்டென்ஷன் இருக்கு, நாலேஜ் இருக்கு, ரீசன்ஸ் டு பிலீவ் இருக்கு. வாட் ஆர் த த்ரீ மென்டல் ஸ்டேட்ஸ்? என்ன டிஃபரன்ஸ் மூணுத்துக்கும்? He wanted to do it. Yes, then.
So, past he has the knowledge and the wantonness before the act, and or by which means at the time of employing those means. So he don't have the intention prior to the act, but doing.
Prior illa. And the time there was intention da, and the mental state da. Now let us define like this. Reasons to believe. For example, it is defined in section 26. Reasons to believe is defined in 26. அதை நோட் பண்ணிக்கங்க. Reasons to believe is section 26. அதை படிங்க. Okay. Now, supposing ஒரு எக்ஸாம்பிள் சொல்கிறேன். ரீசன்ஸ் டு பிலீவ்க்கு ஒரு எக்ஸாம்பிள். ஒருத்தன் வந்து நைட்டில் கதவை தட்டி இந்த மாதிரி நான் வந்து ஊருக்கு போகிறேன், என்கிட்ட ஒரு 10 sovereigns ஆஃப் கோல்ட் ஜுவல்ஸ் இருக்குது, நான் வந்து இது வந்து 10 sovereigns ஆஃப் கோல்டு லெட்டர்ஸ் அஸ்யூமஸ் 10,000 நான் இது வந்து 3,000 உங்களுக்கு கொடுக்குறேன் அப்படின்னு கொடுத்துட்டு நீங்களும் 3,000 சந்தோஷமாக வாங்கிக்கிறீங்க. Now that man has not told you that it is a stolen property. He has not told you. உங்களுக்கு சொன்னால் தான் நாலேஜ் வரும். நான் திருடினேன் அப்படின்னு சொன்னால் அது நாலேஜ் வந்துடும். பட் that is reasons to believe that it is a stolen property. இது ஒரு எக்ஸாம்பிள் for reasons to believe. That will be taken as an average man's reasons to believe that it is a stolen property. I am just giving an example. Alright. This is the lowest in the மூணு category lowest form of mental state. Now knowledge. Now வந்து I may not have sit down. I may not have intended to cause that act, but I know that by that act this will be the result. எப்படி அப்படின்னு கேட்கலாம் நீங்கள். எனக்கு அந்த ஆக்டை I did not intend to do this, but I know by this act I would cause this result. ஏதோ ஒரு எக்ஸாம்பிள் சொல்ல முடியுமா? சடன் ப்ரொவிஷனலி இன்டென்ஷன் இருக்குல்ல, சடன் ப்ரொவிஷனலி இன்டென்ஷன் இருக்குல்ல உங்களுக்கு. சடன் ப்ரொவிஷன் அவன் ப்ரொவோக் பண்ணுறான், நம்ம அவனை அடிக்கணும் தானே அடிக்கிறோம். தட் இஸ் இன்டென்ஷன். பலி கொடுக்கறது இன்டென்ஷனே இருக்கேன். பலி நரபலின் இன்டென்ஷனே இருக்கு. அவனை கொலை பண்ணணும் நரபலின்னு தெரிஞ்சு தானே பண்ணுறீங்க. No, reason to believe is you have an intention to do it. Yes, சொல்லுங்க. Yes, one very close to it. So you don't intend to cause the death of a individual, but you have knowledge that by this act you are likely to cause the death of certain individuals. அதனால murder கேஸில் you will see intention, knowledge ரெண்டு இருக்கும். reasons to believe வராது. body offensesல you can take it, reasons to believe வராது. only intention, knowledge. I'll tell you another interesting place where this distinction is made. So knowledge is something, is a slightly lesser degree of intention, but in certain offenses both knowledge and intention are treated on par. Now intention, why it is even worse அப்படின்னா, உங்களுக்கு நாலேஜும் இருக்குது, நான் இதை பண்ணால் இது நடக்கும் நாலேஜ் இருக்குது, பட் யூ ஆல்சோ வாண்ட் டு டூ இட். இட் இஸ் யூ ஆர் கோயிங் ஒன் ஸ்டெப் ஹைட் ஆஃப் நோயிங். இப்போது a man drives rashly. இந்த மாதிரி நம்ம ஒரு crowded placeல நேராக கொண்டு வந்து வண்டி ஓடுறாரு. He doesn't know you, but he knows that at least 2-3 people will die. He will be liable for knowledge, not rationalized knowledge. Rationalized அதுக்கு ஒரு lesser form, அதையும் explain பண்ணுறேன். Lesser form of mental state, அதுக்கு let's not go into that. It is a knowledge. Supposing he goes on a shooting spree, கண்ணை மூடிட்டு ஷூட் பண்ணுறாரு இந்த க்ரௌடில். He doesn't have a grudge against you or Mr. Karnanidhi or anybody else. He just shoots kanna mudittu. He knows that a few people will die. That is knowledge. But kanna thoranda, he knows that I am going to shoot you and does it. It is intention. That is one step above knowledge. So நீங்க இதில் பார்த்தீங்கன்னா even in culpable homicide not amounting to murder, distinction ரெண்டு பார்ட்டாக பிரியும். 3041 part 2 part 1 பார்த்துருக்கீங்களா? பனிஷ்மெண்ட் படிங்க. You read that provision 304 part 1 and part 2. You will see where it is done with intention, the punishment is more. Where it is done only with knowledge, the maximum punishment is less. That distinction is made in part 2. This is the reason why mental state intention is slightly put on a higher pedestal. So இது பார்த்துட்டிங்களா? இப்போ வாலண்டர்லி நம்ம பார்த்தோம் இல்லையா? எந்தெந்த செக்ஷன்லலாம் வாலண்டர்லி இஸ் யூஸ்ட் இன் பாடி அஃபென்சஸ்? எனி ஐடியா? 323 324லாம் இருக்கா? சரி, இப்போ நம்ம வாலண்டரிலின்னு படித்தோம்ல 39ல், இன்டென்ஷன், நாலேஜ் அண்ட் ரீசன்ஸ் டு பிலீவ், அது மூணுமே அப்ளிகபிளா 323க்கு? ஐபிசி வச்சுருக்கீங்களா யாராவது? படிங்க.
Punishment for voluntarily causing hurt. Whoever expert in the case provided for by section 334 voluntarily causes hurt shall be punished with the imprisonment of either description for a term which may be extended to 1 year or with fine which may be extended to 1000 rupees or with both.
Now அப்படியே திறந்து செக்ஷனை. இப்போ வாலண்டரிலி காசிங் ஹர்ட் பார்த்துட்டிங்களா? இப்போ வாலண்டரிலிக்கு மீனிங் எங்கே பார்த்தோம்? 39 அதில் 3 மென்டல் ஸ்டேட் இருக்குது. மூணுமே அதுக்கு அப்ளிகபிளா? படிச்சிட்டோம் நீங்கள். அந்த 3 மென்டல் ஸ்டேட்டும் அப்ளிகபிளா ஃபார் 324 ஆர் 323? ஆமாவா? மூணு அப்ளிகபிளா?
Causing hurt shall be punished.
வாலண்டரிலி இருக்கிறதுனால 3 மென்டல் ஸ்டேட்டும் ஏதாவது ஒன்று இருந்தால் போதும்ன்றீங்க. Now take 321.
Yes, voluntarily causing hurt. Whoever does any act with the intention of thereby causing hurt to any person or with the knowledge that he is likely thereby to cause hurt to any person and thus thereby cause hurt to any person is said voluntarily.
Voluntary cause hurt க்கு reasons to believe இருக்கா?
Voluntary knowledge that
intention knowledge ஓட restrict பண்றாங்க. You see the beauty of the penal code. அங்க 339ல 3 mental states சொல்றாங்க. But when it comes to body offenses, they restricted to 2 mental states. So you should again read every provision. Now if you need voluntary or definition நான் சொல்றதுனால if you apply to 324 you would be wrong because 321 is there. Correct? You have to read that way. Now this idea is to provoke your thinking. Now penal code class எடுத்தா 1 hour 2 ஹவர்ஸ்லாம் பத்தாது, அது போயிட்டே இருக்கும். ஈவன் ஆனுவலி கிளாஸ் எடுத்தாவே பத்தாது. ஆல் ரைட், நவ் திஸ் ஐடியா இஸ் டு ப்ரொவோக் யுவர் திங்கிங். நவ் ஹவு எந்த டெப்த்தில் படிக்கணுன்றதுக்கு நான் ஐம் ப்ரொவோக்கிங். இட் ஜஸ்ட் நாட் சீட்டிங், ஏமாத்துறான் அப்படின்னா சீட்டிங் கிடையாது. சீட்டிங்னா என்ன? வாட் டிட் லார்ட் மெக்காலே ஆர் சார் ஜேம்ஸ் பார்னஸ் பீகாக் சே, அதுதான் ரெலவெண்ட் ஒழிய நம்ம நினைக்கிற சீட்டிங் கிடையாது. ஆல் ரைட், நவ் இந்த 39ல் இருக்க 3 மென்டல் ஸ்டேட் இருக்குல்ல, அந்த 3 மென்டல் ஸ்டேட்டுமே there is has been incorporated in one offense. Anybody can say which offense? Can anybody say then which offense? மர்டர் இல்லை மர்டரில் இப்போ இந்த ஹர்ட்டுக்கே மூணாவது இல்லை, அப்போ மர்டருக்கு எப்படி? சீட்டிங்லேயும் இல்லை, சீட்டிங்கில் இல்லையே, சீட்டிங்கில் டிஸ்ஆனஸ்ட்லி ஃப்ராட்லண்ட்லி தான் இருக்கு. நோ, இந்த penal code we are now talking about penal code. Now take 499. 499 defamation. Take 499. 499 if you see, all the three mental states will be there. Whoever publishes with the intention of defaming, knowing that he is, அதாவது இன்டென்ஷன் இருக்காது. அது எப்போ டிஃபரன்ஷியேட் பண்ண முடியும்னா, சப்போஸிங் A makes a statement against B with intention to defame and C publishes it. C does not intend to defame him, but he has knowledge that it, அது மட்டும் ரெஸ்ட்ரிக்ட் பண்ணல, he has reasons to believe that he is defame இருந்தால் கூட போதும். You see the third ingredient இருக்கா? Alright, you read 499, you will find all the three mental states incorporated in section 499. Alright, now so far as these three mental states are concerned. Alright, now we talked about the fourth mental state, rashness and. Alright, what is negligence, what is rashness? Penal code defined அது எங்கே defined? எஸ்னா உடனே சொல்லணும், which provision சொல்லணும். இல்லை, it is not defined. எங்கே இருக்கு டிஃபைன்ட்? எங்கே இருக்கு? வேர் இஸ் இட் டிஃபைன்? ஸோ there are two mental states, rashness and negligence. So if it is not defined, what is the definition that you should give? What is the definition that you have to give? What is the definition you should give? Na quotes இப்போ the 160 years இருக்கு. When it comes for interpretation, you will say more than the normal. ஒருத்தர் abnormal வாரு. What is normal? What is normal? So rashness has been defined like this: conscious of the impending danger, but going with the hope that will not happen to him. That is rashness. அதாவது ஒரு டேஞ்சர் இருக்குன்னு இஸ் அவேர், பட் தனக்கு நடக்காது அப்படின்னு நினச்சி போகிறது தான். ஸோ இந்த மென்டல் ஸ்டேட் இஸ் ஸ்லைட்லி லெஸர் தென் நாலேஜ். இஃப் இட் கோஸ் டு நாலேஜ், இட் கோஸ் தேர் in the other offense of culpable homicide not amounting to murder or murder. ஏன் ரேஷ்னஸ்ன்னு ஒரு கேட்டகரி வந்துருக்குன்னா, கான்ஷியஸ் ஆஃப் தி இம்பெண்டிங் டேஞ்சர். ஒரு பைக்காரர் போகிறாரு, நல்ல சந்திலெலாம் ரைட் பண்ணிட்டு போகிறாரு. ஹீ நோஸ் தட் இடித்தா வரத்துக்கு வாய்ப்பு இருக்குது, அது தெரியும், பட் நான் அதை மேனேஜ் பண்ணிடுவேன். தட் இஸ் ரேஷ்னஸ். ஆல்ரைட். negligence, இப்படி என்ன டெஃபினிஷன்? how do you define? டாக்டர் சர்ஜன் ஒரு வார்த்தை சொன்ன போதுமா? not without proper care and caution. Correct. Without proper care and, that is a fundamental difference. All right, அங்கே அதோடு நிறுத்திக்க கூடாது, நம்ம ஒரு ஸ்டெப் இன்னும் போகணும், இங்கே டெப்த்தில் போகணும். ஆல் ரைட். டாட்னு எல்லாருக்கும் தெரியுமில்ல? வாட் இஸ் அ டாட்? சிவில் ராங். வெரி குட். சிவில் ராங்க்கு என்ன ரெமெடி? வெரி குட், எக்ஸலண்ட். Negligence is a civil wrong or a crime? Yes, it is both a civil wrong and a crime. அதனால தான் MACTOP போடுறீங்க, because it is a civil wrong. இப்போ how many of you are MACTOP lawyers who filed cases in motor accidents? போடலையா? தெரிஞ்சுங்க, இந்த பிரின்சிபல் தான். What you are doing in the tribunal is compensation for the civil wrong. That is why நீங்கள் ஆர்கியூ பண்ணும்போது how many cases you said the finding of the criminal court is not binding. That is not binding because standard of proof is different. அது மட்டும் இல்லை, that is a criminal negligence. In criminal cases, in 304, that is criminal negligence. This is a negligence in tort. Negligence in tort க்கும் negligence in crime க்கும் difference is that it must be gross. Jacob Matthew ஒரு கேஸில் doctor was thought to be, the difference is what is punishable, what is made penal under 304A is not just negligence or just rashness. It is called the culpable negligence or culpable, which has to be gross in nature. What is gross? There is something more than mere negligence or something more than mere rashness. And of course it will depend on facts and circumstances case. So something more than just negligence is supposing there is a heavy object on the terrace of your house, காத்து அடிச்சு கீழே விழுந்தது, somebody dies. Cases have said this is not culpable negligence, but this is a negligence in tort where the owner is liable for compensation. So this is so far as mental states are concerned. Now with this background, you must not stop here. You must all go to see every penal provision and see what is the mental state that is prescribed. அது மட்டும் இல்லை, there is a difference or gradation in intention, in knowledge also. There are 2-3 offences where the resultant act is death, but punishment is different in penal code. ஒன்று 304A, என்ன resultant act? Death. Murder resultant act என்ன? Culpable homicide not amounting to murder என்ன resultant act? Punishment different ah? Why? Why? Mental state, degree of culpable mental state varies. Sudden provocation la, you have to understand it scientifically. Degree of culpable mental state varies. The least form of culpable mental state you find in 304A, rashness and negligence. அதுக்கு next form of culpable mental state you will find culpable homicide not amounting to murder. அதுலேயும் intention knowledge இருக்குது. அதுக்கு கிளாஸ் எடுத்தோம்னா it will take some hours. ஸோ அதுக்கு இப்போ போக வேண்டாம். I don't want to confuse you further. Now the idea is to provoke your thinking. அதுக்கும் you have intention knowledge, but you still have lesser form of lesser punishment. But highest culpable degree of culpable homicide, the highest culpable mental state, you have murder, where you can even punish the person for sentence him to death also. So adiliyum varying degrees. So all these varying degrees of mental states you must understand in order to appreciate penal law. Alright, now I am going to just take you to the 4 stages. அது எந்தெந்த இடத்துல penal codeல இருக்குன்னு சொல்லிட்டு I am not going to take you to any specific provision. Alright, now the next stage is preparation. Correct? நம்ம இப்போ என்ன சொன்னோம்? To start with, preparation and mental state alone by itself is not punishable. That's what we started with. Preparation not punishable except for one preparation to wage war etc. The exception விட்டுடுங்க. Don't confuse yourself with that part. Attempt is punishable? Yes. Alright. In many cases there is a thin line of difference between preparation and attempt. Correct? எப்படி இதை distinguish பண்றது? How do you distinguish this? Huh? Yes. Yes. சரி, ப்ரிப்பரேஷன் டு ரைட். வேர் இஸ் இட் டிஃபைன்ட்? அட்டெம்ப்ட்டுக்கும் ப்ரிப்பரேஷனுக்கும் எங்கே டிஃபைன் ஆகிருக்கு இன் பீனல் கோட்? எப்படி நீங்கள் இப்போ சப்போஸிங் ஒரு டிஃபென்ஸ் எடுக்கிறீங்க, இட் இஸ் நாட் அட்டெம்ப்ட், இட் இஸ் ஜஸ்ட் ப்ரிப்பரேஷன். ஒரு டிஃபென்ஸ் எடுக்கிறீங்க, அப்போ அந்த டிஃபென்ஸுக்கு ஷுட் யூ நாட் அண்டர்ஸ்டாண்ட் த டிஃபரன்ஸ் பிட்வீன் திஸ் ப்ரிப்பரேஷன் அண்ட் அட்டெம்ப்ட்? எனிபடி கேன் எனிபடி மேக் அன் அட்டெம்ப்ட்? த்ரெட்டன் இல்லை, த்ரெட்டன் தனி அஃபென்ஸு, தட்ஸ் நாட் ப்ரிப்பரேஷன் ஃபார் அட். சரி, ஒருத்தர் வந்து கிணத்துல போய் நிற்கிறார், வெல் இஸ் ஸ்டாண்டிங் ஆன் த parapet wall of the well. His intention is to jump னு வச்சுப்போம். Is he at the stage of preparation or attempt? Why? ஆல்ரைட். ஸோ அப்போது ஒரு நம்ம சயின்டிஃபிக்காக லெட்டஸ் டிஃபைன் இட். நீங்கள்லாம் க்ளோஸாக வரீங்க, பட் வி ஹேவ் டு ஹேவ் அ டெஃபினேஷனில். இப்போ இந்த எக்ஸாம்பிளுக்கு நீங்கள் ஈஸியாக சொல்லிட்டீங்க. ஒரு ஆள் வந்து ஸ்மகிள் பண்ண போகிறார் அவுட் சைட் தி கண்ட்ரி, he wants to smuggle certain goods out of the country. அவர் எடுத்துகிட்டு போகிறாரு. ஆன் த வே போலீஸ் இன்டர்செப்ட் him. அவர் போய் ஷிப்பில் ஏற்றணும், அதை ஆர் போட்டில் ஏற்றணும். ஆன் த வே போலீஸ் இன்டர்செப்ட் him. வெதர் இஸ் a ஸ்டேஜ் ஆஃப் ப்ரிப்பரேஷன் ஆர் அட்டெம்ப்ட்? அவர் இன்னும் போட்டில் ஏற்றலை. வெதர் இட் இஸ் அட் த ஸ்டேஜ் ஆஃப் ப்ரிப்பரேஷன் ஆர் அட்டெம்ப்ட்? இப்போ திருப்பி வந்துருக்கலாம்ல, யூ குட் ஹவ் கம் பேக்கில். போட்டில் ஏற்றுற வரைக்கும் எஸ் யூ கேன் கம் பேக்கில். போட்டில் ஏற்றுறது தான் அட்டெம்ப்ட்டு. இப்போ வெல்லுக்கு மட்டும் ஏன் அது மாதிரி சொல்லுவேன்? ஈஸ் ஆக்டிங் அப்பான் வெளில நிற்கிறாரு, அந்த வாலில் நிற்கிறாரு. See, now let's understand this concepts. First understand பண்ணிங்க, principles understand பண்ணிக்கங்க. அப்புறம் நம்ம all of us have this confusion or attempt. நமக்கு மட்டும் இல்லை, let us understand that நமக்கு மட்டும் இல்லை, till recently வரைக்கும் Supreme Court also had this difficulty about defining attempt. I'll tell you why. இப்போ அதெல்லாம் படிக்கும் போது will you find it very interesting. The common law principle is a principle called locus penitentiae. LOCUS, I'll spell it exactly. POENITENTIA, I think so. It's a Latin word, so spelling might vary. நான் அந்த நோட்டும் உங்களுக்கு I'll circulate it to you. எனக்கு கொடுத்துருங்க. Principle இதுதான். If the person is in a stage where he can retrace his steps and change his mind and retrace his steps, is still at the stage of preparation. Where he is in a stage where he can't retrace it, but he has not yet accomplished the act that he intended, then it is a stage of attempt. In the definition purida, is it clear? When he is at a point of changing his mind and retracing steps, then he is still at the stage of preparation. Where on the stage தாண்டி is at the stage where he cannot retrace, அவர் மனசை மாற்றிக்க முடியாது, because already he is entered into the act. Alright, now law அவ்வளோ சிம்பிளாக இல்லை. இன்னும் டெப்த்துக்கு போனோம் இப்போ நம்ம. திஸ் இஸ் தி ஃபர்ஸ்ட் பிரின்சிபல் இன் டிஃபைனிங் தி ப்ரிப்பரேஷன் அண்ட் அட்டெம்ப்ட். நவ் லா இஸ் நாட் as simple as that. Now take the definition of 307. 307 நம்ம ரெகுலராக பார்க்குறோம். attempt to murder. In a definition,
whoever does any act with such intention or knowledge and under if he by that act caused death, he would be guilty of murder. Shall be punished with imprisonment of age description for a term which may extend to 10 years and shall also be liable to fine. And if hurt is caused to any person...
punishment. Now, in the body of the section, India, the attempt into water now. Body of the section. I am not saying the heading. Now, this is the provision.
Defense attempt to murder, but you will find in that section that the word attempt is not employed. If by that act he had accomplished it, he would have caused death. So on the act pannidhu, but he couldn't accomplish it for some reason, then it is attempt. So the locus penitentiae principle sonnanla, that is applicable for attempt to murder. Okay. Now go to 309.
Whoever attempts to commit suicide and does any act towards the commission of such offence.
Stop here. Now attempt, what is the understanding of an attempt? He has already entered or committed some act. He is unable to retrace his steps. That is 307 definition.
But 309 says whoever attempts and does any act towards the commission of the offence. Appana attempt ku enna artham? Now attempt liye you already have done something towards the commission of the offence. That is the understanding. That's a law. Why is this redundant 2-3 words saying you attempt as well as does any act towards the commission of the offence? Any other offence illa adukku 3 abutment ku. What is the meaning that you should give to that 3 words, extra words? Na solradhu puriyudha? You understand the difference? You are able to understand the difference. Now go to 511.
Whoever attempts to commit an offence punishable by this code with imprisonment for life or imprisonment or to cause such an offence to be committed, and in such attempt does any act towards the
In such attempt does any act. Now, what is the understanding of our attempt? He already has done some act towards accomplishing, but he was not successful.
So, what is the meaning that should be attached to these 2 words? Does any act towards the commission? Now, this has caused trouble, not only to us, but it had caused trouble to the Supreme Court as well. They also found it difficult to define what attempt meant in these sections, because though section 307 did not employ the word attempt, but it defined attempt so far as attempt to murder alone is concerned, but so far as other offences are concerned, there is no definition for attempt. Now, unless you understand the meaning of word attempt, you will not be able to differentiate between preparation and attempt. So the Supreme Court employs almost similar words like this: all attempts made to define attempt as ended in vain. So they try to kind of try and they define in 2 cases. The earliest case was in 1967. The second case was in 1983 SEC page 557. The first case was 1961 Supreme Court 1698, and 1969 1 SEC 157. So அதில் வந்து ப்ராடாக என்ன சொல்கிறாங்கன்னு சொல்லிடுறேன். நீங்கள் படிங்க, எல்லா ஜட்மெண்ட்டும் படிக்கணும். படித்தா தான் you will understand the importance of what I am trying to tell you. Broadly they say this: the understanding that attempt is the penultimate act. Penultimate act என்ன? Last but one act before the crime is not the correct approach.
That is the locus penitentiae principle. Locus penitentiae principle badiki, you almost enter into the act, but you are not able to, you are not successful. So that is the penultimate act before the actual crime. That principle always is not correct. That's a too narrow a definition for attempt. They say if there is an intention that you can gather from the circumstances, you can call it attempt. So in the smuggling case la enna solranga, but for that he had a clear intention to smuggle, though he could have changed his mind by applying the principle of locus penitentiae. You could have changed his mind even at the last minute, but don't apply it too narrowly. You say that it must be proximity in intention, not proximity in the final act. So that was sought to be clarified, and it all depends on facts and circumstances case. So this is how attempt has been clarified in all these judgments. So whenever you read any provision, you have to go at this depth. Knowledge is power. You will steal a march over others only if your knowledge is better than the others, not by just saying that we might win one case by so many methods, but knowledge is something that you must all have. That is the powerful weapon that all of us must acquire. Now this is all fine. Now another interesting thing, this number 4 stages vandutom. Actus reus, it's all defined in penal code. Actus reus நம்ம படிச்சிரோம். Punishment, அதுக்கு punishmentலாம் provide பண்றோம். Now in property offences, I'll stop whenever you want. in property offences, one more interesting thing, இல்ல எங்கெல்லாம் நமக்கு வந்து problem வரது மட்டும் I am touching, because wherever it is defined, no problem, we will understand. Always you have definitions. Property offences la na sonna modaliye, there is something called dishonestly and share. Enga defined adu? Where is it defined? 24 and 25, correct? 24. Seri, dishonestly padinga.
With the intention of causing wrongful gain to one person or wrongful loss to another person is said to that thing dishonestly.
Correct. So these are the courts have said wrongful loss irundha podum, corresponding wrongful gain to another person need not be there. Correct, Mr. Karnadi. If there is anything, you correct me. If there is wrongful gain to one person, corresponding wrongful loss need not be there to the other person. Idella clear ah irukku. Okay. Wrongful loss is defined. Wrongful loss is enga defined? Very good. Wrongful loss, wrongful gain defined? Yes. So padinga, adiyum padinga.
Wrongful gain is gain unlawful means
Yes.
of property to which the person gaining is not legally entitled.
Okay.
Wrongful loss is the loss by unlawful means of property to which the person losing it is legally entitled.
So இது ரெண்டுமே clearly defined. By that act, theft you will find dishonestly. Wrongful loss and wrongful gain. The person who is taking the object is getting wrongful gain. அதில் corresponding wrongful lossum இருக்கு, but that is always not necessary in order to establish dishonesty. There is no difficulty because there is a clear-cut definition. Now the problem arises in the next definition. What do you mean by fraudulently? Irukku section irukku. What do you mean by fraudulently?
Fraudulently, if he does that thing with the intent to defraud but not otherwise.
What do you mean by defraud? What do you mean by defraud? Try attempt. Mali, let's attempt. Now dishonestly clear. Wrongful loss, ஒருத்தருக்கு property offenceல any wrongful gain, wrongful loss clearly defined. What is the reason for one more definition called fraudulently, one more ingredient called fraudulently? What is the reason? ஏன்னா நம்ம
ஒரு cheating வச்சுப்போம், there is some wrongful gain, wrongful loss, right? What is the reason for one more fraudulently ன்னு எதுக்கு கொண்டு வந்தாங்க? What do you mean by intent to defraud? Yes, and do what? Believe do what?
It is not there, but causing him to believe that it is existing.
And do what? And ultimate result is that
Causing loss to
lawful layers the dishonesty வந்துச்சு. That is common to dishonesty.
Morality.
Morality, there is no place in penal law. Okay. Now, this also caused trouble to the courts. So how do we define intent to defraud? As I tell you, intent to defraud, you can bring everything under dishonesty. What is the reason for one more ingredient called fraudulently? They said, wherever there is deceit and injury other than injury caused to property, then we can call it fraudulently. Injury le nama section 44 பார்த்தோம்ல, what are the types of injury? You can cause harm to body, mind, property, reputation. So if there by this deceit, if is injury is caused to any of the other ingredients, then you call it fraudulently. If it causes injury to the property, அது wrongful loss, wrongful gain ல வந்துரும். காசு விஷயம் சம்பந்தம்னா wrongful loss, wrongful gain வந்துரும். If it is any other form of injury, then it is fraudulently. Okay, அதுக்கு condition is deceit. What is deceit? So deceit and injury is defraud. இதுக்கு ஒரு definition கொடுத்துட்டாங்க. What is deceit? What is deceit? Deception, deceit. DECEIT. What is deceit? ஏமாற்றுதல், ரைட்டு. என்ன எப்படி ஏமாற்றுதல்? நான் எதை நம்ப வச்சு ஏமாத்துறது? இல்லை, எதை இன்னத்தை நம்ப வச்சு ஏமாத்துறது? ரெப்புடேஷன் இல்லை, டோன்ட் கோ டு தட். என்ன ஃபேக்ட் நம்ப வச்சு ஏமாத்துறது? அதாவது we have to again scientific thinking. Deceitக்கு ஒரு மீனிங் இருக்கு. What is deceitனா, there is a Latin phrase that all of us must நீ படிச்சிருப்பீங்க, உங்களுக்கு தோணலை. Suppressio veri and suggestio falsi. அப்படின்னா என்னன்னா, you suppress the truth, you conceal the truth and make a statement. அதுவும் deceit. நீங்கள் பொய் சொல்லணும்னு அவசியம் இல்லை. If you conceal the truth, that is, நம்ம சொல்கிறோம்ல, ஏற்கனவே வித்துட்டார் இந்த ப்ராப்பர்ட்டியை, அவர் சொல்லாமல் வித்துட்டாருன்னு. அவர் உங்கள்கிட்ட பொய் சொல்லியிருக்காரா? அவர் நீங்கள் கேட்கல, ஏற்கனவே விற்றீங்களான்னு கேட்கல, உங்கள்கிட்ட சொல்லலை அவர். He has not made a false statement to you, but he has suppressed the truth. Therefore deceit. நம்ம வந்து இதை இந்த scientific manner of thinking இல்லாமையே நம்ம we say, no, he suppressed this fact and sold it the property to me, therefore deception. You have to understand this way. So this is the Latin phrase that you all have to remember. Deceit means suppressio veri, veri na truth, suppress பண்றது. Suggestio falsi, suggesting the falsehood, making a false statement. So both will come under the definition of deceit. And then deceit மட்டும் பத்தாது, there must be a corresponding injury cost. So another thing, this is a must that you all understand in when you are appreciating forgery cases. There was a famous case called Dr. Vimala was state in 1963. அதில் என்ன கேஸ்னா, insurance will be in the name of the car will be in the name of the minor daughter. Car will have some would have met with some accident, and they would make an insurance claim. The mother is a doctor, her name is Dr. Vimala. She signs on behalf of the minor daughter. கையெழுத்து போட்டு பண்ணு. The insurance person denied the claim and said you have made you have committed forgery of your daughter's signature, therefore it is we will not give you. The Supreme Court said no, that is not forgery, because there is no corresponding injury. Even if that daughter has signed, injury illa, insurance company either way should have given the claim, a daughter has signed. So there is no injury caused to the insurance company, therefore, or wrongful loss caused to the insurance, therefore it not come under either fraudulently or dishonestly. The argument was it is causing injury to the insurance company. That was negative. You have to read this judgment also. Dr. Vimala was a state to understand property offences. So merely because somebody has signed, suppose somebody has signed like my name in a sheet of paper, not doing anything else, will it amount to forgery? No. The resultant act must be there. So this is how you must read penal code. On another day I will let you know the difference between culpable homicide and murder also. Your attention, we will do that one more day. All of you must have the penal code with you, or we must screen the penal code. If you have a facility, we can, when you can read penal code, we will do it one more day. The idea is to provoke your thinking. Now this is just the tip of the iceberg. Penal code doesn't stop here. Penal code has got, it just started. Now this is how you must read penal code. And the idea was to provoke your thinking, and I think I have taken more time. Attention span I know will come down, so I will stop here. Thank you so much for giving me the opportunity. We'll meet once more. Thank you so much.
I think he is not only read the mind of Macaulay, but the mind of President also. Just now. He told me that he has to take another class for that. Thanks, Your Lordship has visualized every examples by the visual meanings. It's a great opportunity before Your Lordship that I am being loaded in front of you. Thanks, Your Lordship. Now I request my dear beloved brother to give thanksgiving address.
Vote of thanks is not a ritual, it is a duty. Gratitude is the completion of the thankfulness. First of all, I thank Lordship Justice Mr. Sunder Mohan for giving an excellent lecture. I may not be practicing in a criminal law, and I was astonished by the way the matter was been dealt with, and the provisions, each and every provision has been dissected, like operation being conducted in a hospital, and each and every provision has been dissected, and it has been completely analyzed. I have not even read these provisions before, because I would be practicing mainly on bail and anticipatory bail application, so I may not have this opportunity to read these provisions. I thank my Lordship, and we, the office bearers of the association, when we met the Lordship and asked for an date to have a lecture, Lordship was very much interested, and he was, without having a second thought, he has immediately consented to give a lecture. And we, with the fourth state of mind, that is, I have noted down for the intention, knowledge, reason to believe, and rash and negligence, we would be inviting my Lordship for another opportunity to give a lecture with more, because now, as of now, the time is very short, and I was also very much intense, because I was not recovered from the way my Lordship has rendered this lecture. So I sincerely thank my Lordship for giving an excellent lecture, and I would thank Mr. ANDIRAJ President, Mr. ANBARASU Secretary, for making this orientation committee, because this was the intention to enlighten the members of the bar, especially the junior members. And I would specifically mention that whatever all the requests made by the members of the bar are being heeded by the presidents and other office bearers of the association. I would thank Mr. ALAGUMANI, Chairman Orientation Committee, Mr. Peturajesh, Organizer, Mr. Karnadadi, Coordinator, Das, Committee Members, Das, Jyoti Ramlingam, Shivashankar, Joseph Jerry, and myself. And I would fail in my duty if I fail to thank all of us, because in the late hours of evening, and all the members of bar has been here, and have even been, despite the tiresome work and commitments, we had been here. And I thank all of you for being here, and I hope all of you have enjoyed this session, and more sessions would be conducted regularly every Wednesday. And I thank all. It's a request for the welfare of the bar also. We have a YouTube channel in MBHA, so I request all the members of the bar to subscribe to the channel, so that we could do more things for the members of the bar. Thank you very much.
இந்த வீடியோ மட்டும் ஒரு 100 தடவை பார்த்தா தான் சுத்தமாக புரியும் போல. அட்லீஸ்ட் இந்த ஐபிசி புக்கை வச்சுட்டு ஒவ்வொன்றா தேடணும். வேறு ஆப்ஷனே கிடையாது. அதனால் எங்கள் தலைவருக்கு வந்து இந்த யூடியூப் சேனல் ஆரம்பித்து இந்த யூடியூப்பை ரன் பண்ணுறதுக்கும் ரொம்ப நன்றி சொல்லணும். ஏன்னா இந்த வீடியோ மட்டுமே கிட்டத்தட்ட 100 ரூபா பார்த்தே ஆகணும். We are supposed to get into the mind of Mekelle. I am thankful, Lordship.